Good afternoon, everyone. I think we'll start now. As most or some of you will know, my name is Sasha White, and I'm chairing today's presentation on behalf of Landmark Chambers, where we are seeking to obviously explain the recent High Court decision in Dennis, how it deals with the Supreme Court decision in Hillside, and the effect effectively on planning permissions, drop-in permissions, and severability of permissions. Now, for the purposes of today, we're going to deal with the past, the present, and the future in relation, as all of you know, to an incredibly complicated area of law, and that is the interrelationship of Section 73, Section 96, and what happens where there are various different permissions in play and whether they are affected by implementation or existence, so to speak. Now, we've got four excellent colleagues of mine to present. Firstly, Anjoli Foster will talk about the past and give effectively the context of effectively the decision in Pilkington, which most of you will know, the 1973 decision, which obviously deals with how you approach two extant permissions and how they effectively, what the effect in law is of an implementation of one of them, and the Supreme Court decision in November 22 in Hillside, which practically applies the Pilkington principle and reaffirms it. Then we'll move on to Alex, who is junior counsel in the Dennis case led by Jenny, and he will effectively seek to tell you about the present and what the key findings of Mr. Justice Holgate were in that decision. Then we will move to the future, and Ashley will seek to tell you about how to ensure permissions can or cannot be severable, practical application of the decision in Dennis for those of you obviously concerned with such matters. And then finally, Jenny will give again a practical insight in how to deal with large outline schemes like the one in Southwark that was subject to the Dennis litigation. Now, just briefly to say a few things about my colleagues, most of them will be familiar with you. Anjoli, first of all, is a very successful junior on the government panels, therefore used by the government to advise them, and she represents developers, local authorities and Rule 6 parties in all matter of planning litigation, and is ranked in both Chambers, Legal 500 and the Planning Magazine. The same is also true of Alex, who is one of our strongest juniors, and he represents a lot of clients, claimants, as he obviously did in Dennis with Jenny, as I've said, and he's ranked again in all the directories. Thirdly, we have Ashley, who we're delighted to have at Landmark now, who's got a very, very successful practice, again representing all three streams of those that operate in the planning field, developers, local authorities and Rule 6 parties. He is very eminent in law, writes a lot about the law, and will no doubt provide an excellent presentation. And lastly, Jenny, who is of King's Counsel and is joint head of Landmark, and she carries out that role superbly and diligently, and she obviously represented the claimant in the Dennis case successfully. So those are our four speakers, and I think I will commence with the first substantive presentation from Anjoli. So Anjoli, welcome.
Thank you, Sasha. Hello, everyone. So as has just been mentioned, I'll be going through a recap of the case law on inconsistent planning permissions and drop-in applications just prior to the recent Dennis against Southwark case, which Alex will then go through. Now, obviously, this recap is useful by way of background to put the court's decision in Dennis into context. And I'll also be speaking through the rationale behind why the courts have laid down the principles they have thus far in this area. And looking at this rationale, I think, behind the court's decisions is a really useful exercise, because once we know that and the mischief the courts are trying to prevent in this area, this can then help us to work out whether there are any potential ways forward for drop-in applications within the current legal framework. So starting out with the first case in the story, which I'm sure many of you will be very familiar with, and that's the case from 1973, the case of Pilkington against the Secretary of State for the Environment. Now, the facts in Pilkington were fairly simple. We had a landowner who had a plot of land which had the benefit of two separate planning permissions. The first planning permission granted permission for a house on one part of the plot of land with a condition that the rest of the plot remained open. And the second planning permission, a completely separate permission for the same plot of land, was for a house on a different part of the plot, again with a requirement that the rest of the land remained open. Now, this was clearly a case where we had two overlapping planning permissions and they were inconsistent with each other. And the landowner rather cheekily claimed that they could rely on both permissions to build out both houses on the plot of land. Now, unsurprisingly, the court said, no, you can't do this. And the judges found that once the landowner had built out the house pursuant to the first permission, they couldn't then build out the other house on the second permission too. Now, the court explained the principles that it's absolutely legitimate to make numerous planning applications for the same site, and also perfectly legitimate for there to be numerous inconsistent planning permissions which have been granted on the books by a local authority, but you can't necessarily implement and build out all of these permissions. So in essence, you can't pick out certain elements of one permission, build that out, and then pick out certain elements of another permission. And so was born the Pilkington principle, which we've then seen work through modern case law and how it practically applies, which we'll move on to in a second. And there are various descriptions of exactly what the Pilkington principle is in the case law and in various articles, but the one I've set out on the screen there is the one that I found most useful. And that's essentially where you've got two or more planning permissions that have been granted for the same area of land, and development has been carried out under one of those permissions. If that development has made it physically impossible to carry out development approved by another consent, then that consent may no longer be relied upon. And the rationale on the simple facts in Pilkington, I think most would agree makes sense. On the facts of that case, in granting each of the permissions, the local authority clearly found that one house on the plot of land in question was acceptable as long as the rest of the plot remained open. They hadn't considered or countenanced the impact of two houses on the land, and that explains the reason the court decided the way they did. And in essence, it boils down to the problem that the courts are trying to avoid, which we see played out in more recent case law, is the courts are trying to avoid this risk of development taking place under a mixture of permissions where the potential impacts of that combination of development has never actually been assessed as a whole. Now, obviously, we've seen that principle play out in the very simple facts of Pilkington, but then what happens when you start to apply this principle or try to apply this principle to more complicated facts, and in particular to the practice of drop-in planning permissions, which have often been used by many to make amendments to larger, more complicated schemes. And that was a question which went all the way to the Supreme Court in the Hillside case, which again, I'm sure many of you will be familiar with and are grappling with the practical implications of the Supreme Court's judgment. What we had in Hillside in terms of the facts was an original planning permission that had been granted for circa 400 dwellings on a large site, with the master plan attached to this original permission showing the exact location of every dwelling and also the road layout within the estate on the site serving each of these 400 dwellings. Now, over the years, since the original permission had been implemented, various other planning permissions, or drop-in planning permissions, we can call them because that's essentially what they were, had been granted and built out for individual dwellings on part of the site. And so the location of some houses had departed from the original master plan attached to the original permission. And the question, which the court was asked, was whether the developer could still rely on the original permission to carry on building out the rest of the 400 houses, despite the departures that had been made on the ground pursuant to building out all the individual drop-in permissions. And in that case, the Supreme Court reaffirmed and approved the Pilkington principle and found that it applied to this scenario too. The court found that it was now physically impossible to build out the development approved by the original permission in accordance with its terms, because of the development that had taken place pursuant to all of the drop-in permissions. And so the court found that the original permission could no longer be relied upon to authorise any further development. Now, importantly, for our purposes, and in particular the Dennis case, one of the ways in which the developer in Hillside tried to avoid what's known as, or referred to by some as, this Pilkington problem, was to try to argue that the original permission for the 400 dwellings was a severable permission. And so, in other words, the developer argued that this original permission didn't grant permission for 401 dwellings as a whole, but rather this permission should be interpreted as separately granting permission for each dwelling, so that the ability to build out part of the development did not depend upon whether it was still physically possible to develop all the other parts of the development on the site in accordance with that permission. And the Supreme Court rejected this argument on the facts of Hillside, and they found that this original permission for the circa 400 dwellings was not a severable permission. The court went on to say that unless there's some clear contrary intention within the permission, and that's the key wording used by the court, clear contrary intention. Remember that phrase, because we'll come back to that in Dennis. Unless there was something in the permission which was clearly contrary, it will be assumed that a permission for a multi-unit development is granted for an integral whole, i.e. it will be assumed that a permission is not severable. And the court helpfully explained the rationale for why they thought this was the case and why they came down on this side of the fence. And that's because when granting the original permission in this case, the court found that the local authority will have and did consider a range of factors relevant to the development when deciding to grant permission, and they would have assessed it as a whole. So, for example, the local authority assessed the exact number of dwellings that was acceptable on the site, the overall layout of the road within the estate, and the public benefits of the scheme as a whole. And the court, when looking at that permission, found that the local authority hadn't authorised the developer to combine building only part of the proposed development together with building something else different from and inconsistent with the approved scheme on different parts of the site. And again, we can see that this links back to Pilkington in terms of the problem that the courts are trying to prevent, or the mischief, and that's that the court are clearly trying to avoid this risk of development continuing to take place under an existing permission, even where there have been departures under a drop-in permission, where the impacts of the combination of development under the existing permission and under the drop-ins has never actually been assessed as a whole. And it's that mischief that the courts have found that the law doesn't allow, and that's the rationale we can see playing through in both these cases. And so in terms of the main takeaways from Hillside, before we then turn to look at what the court found in Dennis, are that firstly, as I've just gone through, even though the court refused to accept that the permission in Hillside was a severable permission, they did still leave the door open for the existence of severable consents. And what they said is there needs to be a clear intention in the permission itself. And that's where the Dennis case comes in, of course. But already from the reasoning in Hillside, I think it appears pretty difficult that one would be able to retrospectively argue that a permission that's already been granted is severable without having purposefully designed it in this way, which one might be able to do in the future. But I think you can tell already from Hillside it's going to be pretty difficult to argue that retrospectively. Other points that the court confirmed, which are helpful when it comes to drop-in permissions and amending larger schemes, is that the court confirmed that everything built out under an original permission before a physically incompatible drop-in permission is implemented remains lawful. Now, this point wasn't clear under the law before, and so it's very helpful to have the Supreme Court plug that gap. And that principle can be very useful in some scenarios where you want to make a drop-in application and you don't need to return back to the original permission. So, for example, if you have a large phase development which is mostly built out under an existing permission, and then you make your drop-in application for the final phase of development or the final phases of development, yes, once you start building under the drop-in permission, that means that your original permission doesn't authorize any further development, but everything built up until that stage under the original permission remains lawful, and you won't face any enforcement action for that development that's already been built out. So that could be extremely useful in some scenarios of finding a practical workaround. The court also confirmed that the Pilkington principle shouldn't be pressed too far. What they said is that it's only if the departure from the existing permitted scheme is material in the context of the scheme as a whole. It's only if the departure is material that the original permission can't continue to be relied upon. So if you have a drop-in application which, for example, only differs from the original approved scheme in a minor way, that won't prevent you from continuing to rely on the original permission as well. The Pilkington principle doesn't arise in that scenario. Of course, we've then got the difficulties of what's a material departure, what's a minor departure, and that's going to be a matter of fact and degree in each individual case. The court also finally suggested, when it was put to them, that their decision could cause mass practical problems in the development industry, as the court suggested that another solution to achieving amendments on large schemes would be to simply apply for a whole new replacement planning permission. So either under Section 73 or just a brand new application which covers the whole site and also includes the amendments you want to make. And once that's granted, you can then just build out under that replacement permission. Now, that point was only really covered briefly by the Supreme Court, and they didn't really get into the potential complications that comes with an approach like that. So, for example, applying current planning policy, which wouldn't have been applicable at the time of the existing consent, or potentially adverse implications for community infrastructure levy, and also the mass amount of work it will take in, for example, having environmental statements applying to the whole site. And so perhaps that's an area we can discuss a bit further too. But that was one of the suggestions put forward by the judges in the Supreme Court. Now, before we move on to Dennis, there's just another case as well, which is certainly worthy of mention. And that's the case of Fisk against Tess Valley, which was handed down in December of 2023. So just before the Dennis case. This case didn't receive the same amount of fanfare and headlines as Dennis did, but it's still highly relevant for this area of law. And in this case, again, the court considered this same scenario of an existing permission for a large site, in that case, a solar farm, and the grant of a later drop-in application for part of the site. And an objector in that case had challenged the grant of the drop-in permission, alleging that the local authority had failed to carry out an assessment of the effect on or incompatibility between the drop-in permission and the existing permission. And importantly, for our purposes, the court found, as I've written on the screen there, that there's no legal duty on a local authority to take account of the effect of one permission on another existing permission, even if the two are contradictory. The court said that a local authority is obliged to determine each application on its own merits, even if an application happens to be inconsistent with an existing permission. And now that makes sense as a general principle, because of course we can have decision makers grant inconsistent planning permissions on sites, and then it's up to the developer which one they want to implement. But it does link back again to this rationale that the court is using in Pilkington and Hillside, because if there's no legal duty that a local authority must consider the effects that a drop-in application will have on an existing permission, then there still remains this problem that the courts are trying to avoid, i.e. the risk of development taking place under both an existing permission and an inconsistent drop-in, where the impacts of that combination of development have never been assessed. And so again, when we're looking at practical solutions to try to achieve amendments to large schemes and have things such as drop-in applications, it's this problem that we're going to need to have to try and avoid. And so that wraps up the recap section, and I'll pass over to Alex now, who's going to be looking at the case of Dennis itself.
Hello, everybody, and thank you, Anjoli. So I'll be talking about the Dennis case, what it was about, and what the court's decision was. This was a case about the redevelopment of the Aylesbury estate in Southwark, and in particular, an outline permission from 2015 covering a large part of the estate and the proposed regeneration. It was a big outline permission, a chunky boy, as I understand the younger planners like to say nowadays, phased over several years and building on previous permissions, intended to come forward in bits. So far, so lovely. And that's where our story begins. It was a beautiful day in Southwark, but oh no, what's this? There was a potential issue with one element of the outline. One of the phases of the outline needed to be a bit taller than planned. A higher tower was needed outside the envelope of the original permission. What to do? The problem was this. If the council granted a new drop-in planning permission for that higher tower and then built it out, someone might lawyer up and come along and say, Pilkington applies, as Anjoli just explained. There is an inconsistency between permissions, old and new, and so the developer, you're not able to build out the remainder of your hard-earned outline. A troubling thought. The solution that was proposed to deal with this risk was simple and, as I understand it, reasonably common post Hillside. Under section 96A TCPA, you can apply to make a non-material amendment to a planning permission, a quick and straightforward procedure. So why not eliminate the risk of a Pilkington argument later down the line and insert the word severable into the description of development of the outline using the section 96A process? The argument would go like this. The amendment was non-material because the outline permission was severable to begin with. It's an outline permission. Hillside never referred to outline permission specifically. It's phased, comes forward in stages. Surely that's enough of an indication that it is severable. Let's just make it clear on the face of the permission. Well, on behalf of the claimants, Jenny and I challenged this analysis. We argued the outline was never severable to begin with. We said, firstly, if the argument was that the insertion of the word severable was non-material, then obviously the defendant needed to show the permission was severable to begin with. Usually, materiality is a question for the council, you may well think. But we said severability is not really a matter of planning judgment. The permission is either severable as a matter of law or it's not. It's a question of interpretation. There's only one right answer, and it's ultimately for the court to determine. So the case came down to an interpretation of the original outline permission. If it was severable to begin with, we would have lost because the amendment would indeed be confirmatory only. If it wasn't severable, then we'd win because a change from severable to non-severable is necessarily material. But Alex, why is it necessarily material? Because on one view, severability doesn't actually change the nature of the development permitted by the permission, does it? Well, Alex, in the hearing, Jenny used a phrase that was adopted by the judge in his decision. A planning permission is a bundle of rights. And so we said an amendment must be material if it significantly alters that bundle of rights by disapplying the Pilkington principle that usually applies. And that's what a severable permission is. It's a permission to which Pilkington does not apply, so you don't need to worry about incompatible permissions. You can mix and match as you desire. It's like Lego bricks. The possibilities are endless. You can, for example, take half of a Lego Hogwarts castle and half of a Lego Millennium Falcon and just stick them together. No need to follow the instructions. Severability is a creative space. There are no wrong answers. By contrast, if a permission is not severable, if you want to finish your Lego model, you do need to follow the instructions that come in the box. So in the hearing, once all that was cleared up and we'd fully explained the nuances of the Lego Star Wars universe to a receptive Mr. Justice Holgate, the sole question for the court was simple. Was the original outline permission severable or not? And in the hearing, we set out the legal principles for interpreting planning permission, most of which will be well known to planning lawyers. But there's a good one buried a little deeper in the authorities, which is that extraneous document can form part of the permission itself for interpretation purposes if directly incorporated into it as part of the grant of permission, which is what happened here. Permission granted in accordance with the DAS, the planning statement, etc. So what that means is we could turn to and rely on the DAS, the planning statement, etc., to show that although the permission was phased and in outline, it was intended to operate as a coherent whole within certain parameters. In other words, there was no obvious place in Hogwarts Castle for Chewbacca's cabin. The castle architect would have raised an eyebrow at the very least. Yes, you can build a castle in stages, but the underlying assumption is still that you build the whole thing as it was originally designed. So applying Hillside, there was no contraindication that the permission was intended to be severable, no telltale signs of a mix and match approach being acceptable from the outset. Permission was granted in 2015 for a coherent, interconnected whole, albeit one that could come forward in stages. Thus, the amendment could not be described as non-material, and it was unlawful to make this change via Section 96A. And that's why the case succeeded in a nutshell. Now, as my more learned colleagues will shortly tell you, none of that means you cannot design a severable permission if you want to do that. And there may be some reasons why you don't, but you can in principle do it. But what you can't do is assume that these big old regeneration scheme permissions from the heady pre-Hillside era were always intended to be severable. You'll need some pretty clear wording in the permission and any incorporated documents to make that case. I'll now hand over to Ashley.
Thank you, Alex, and good afternoon, everybody. So I'm going to deal with 4 topics under the heading, how do you ensure permissions are severable at the outset? First of all, I'm going to look at what isn't a clear contrary indication. Then I'm going to say, well, what are we looking for? What sorts of evidence is important and relevant to decide whether a planning permission is intended to be severable, effectively a set of individual permissions. Then I'm going to look at, thirdly, the ITV Studios permission. Not that Pilkington or Hillside arose in that appeal decision, but to see whether the description of that development indicates it might be severable. And then fourthly, rather, and finally, I'm going to deal with how might you frame a permission at the outset in order to achieve severability down the line. So unlike my esteemed colleagues, I've taken a very high-level approach to these slides so that you'll have to listen very carefully to what I say. The first point is, well, what is not a clear contrary indication? And we get some clues from the way that Mr. Justice Holgate deals with this in Dennis. And the first point to make is that obviously he's dealing with the facts of this particular case. He's not purporting to lay down things which could not be clear contraindications, but we obviously get some clues about what in another case is unlikely, either on its own or in combination, to be a contraindication where you've got a multi-unit development. And we remember, of course, we approach all this evidence with the presumption that Lord Sales had in mind in Hillside when he said that a multi-unit scheme is presumed to be a coherent single permission unless you've got clear contrary evidence. So the first thing that we look at is, well, is a grant of planning permission in outline sufficient to be a clear contraindication? And the judge deals with this quite quickly by saying no, because the Pilkington case expressly contemplated the Pilkington principle applying to outline permissions. And if therefore that's the case, it must mean that the simple fact of granting planning permission in outline cannot be enough to indicate a contraindication, that it's to be considered as a single permission. The second point is, well, what about phasing provisions? Obviously, those are very common on large developments. They're common on large outline schemes, such as this one, a regeneration scheme with lots of component parts to it. Well, again, the judge said, well, that's not inconsistent with a single permission. And that's a phraseology that he uses throughout the judgment to indicate whether we're looking at something as a clear contraindication, whether it's inconsistent with a grant of permission, which gives you a bit of a hint to when we get to the final topic about how difficult it's going to be to frame a permission to have something in it that's positively inconsistent with a single permission. Very difficult, I would imagine. The third point he makes is to say, well, what about the physically discrete nature of the phases? And the point being that each phase had its own physically particular area within the red line of the planning permission to which it applies parameters plans, which suggested where individual types and forms of development would come forward. Well, again, he said, well, that's not inconsistent with a single permission. And you can see really where the judge is coming from on those first 3 points, perhaps. The fourth one is slightly more compelling, is that in this particular case, in Dennis, the permission was granted on terms that there were separate time limits for commencement for each different component. And that, one might think, is beginning to indicate that there might be some expectation of the phases coming forward in different times and on their own terms. But the judge said, well, that's not inconsistent. You can have a single permission with different components of it all coming forward. It doesn't indicate that you can disaggregate this permission from its whole. So those things we know are not enough. But as I said, it's not an exhaustive list, and the judge wasn't saying those are the only things that would be inconsistent. But it gives us a bit of a clue as to what we need to be looking for. So moving on to the second topic, then, well, what are we looking for? What is it in a planning permission that's been granted that we need to find in order to indicate that it's likely to have components within it which are severable acts of individual grants of permission for individual acts of development? Well, in terms of the phraseology, the judge says we are looking for an expression that has been expressed unequivocally. So some express indication on the planning permission that the individual components, whatever they are intended to be individual grants of permission and to come forward potentially separately from the whole. He did indicate and contemplate that it might not need to be express, it could be by implication, but that implication must be devoid of equivocation. It must be equally clear, he said, by implication has to be expressed. So we're really looking for something that cannot be avoided on the permission. But interestingly, the judge seemed to go a bit further than just the form and substance, the form rather of the planning permission. He was interested in the substance. And he said, well, really what you're looking for is evidence that the merits of the individual components coming forward individually from the whole was considered, evaluated and approved by the decision maker. And he indicated that there was no evidence in the officer's report, which informed the outline planning permission, or in this case, because it was of a size and scale that required an environmental statement, anything in the environmental statement which indicated you could have the component phases coming forward as individual permissions. And that weighed heavily, it seemed, on the reasoning of the judge. And you would therefore be looking in the individual permissions for consideration in the officer's report or an environmental statement, if there was one, for that evaluation. You'd be looking, for example, for each individual phase to be considered against the development plan and other material considerations like national policy. You'd be looking to see whether those individual components were assessed in terms of their infrastructure requirements, and whether each individual phase could come forward on its own without being reliant on the other phases, or indeed the phase contributions to infrastructure that might well have been agreed as part of the overarching permission. And of course, you're going to be looking for a planning balance to have been undertaken at each individual phase. And one might think, well, that's going to be quite difficult, really, because by their nature of large schemes, there are going to be elements of schemes which are going to be more harmful and elements of schemes which are going to be beneficial. And the planning balance for the whole may be very different and may fall very differently than the planning balance of the individual component parts. So phase 3 may have more harms than benefits, and on its own terms, you might not grant planning permission for that phase, but you might grant permission for the development within phase 3 as part of the overall whole because the overall benefits of the scheme justified it. So that, I would suggest, is going to be quite challenging in reality to find, but nevertheless, that seems to be what you're looking for. So to draw out on point 2, what are we looking for? Well, we are trying to find something which is both either express or by obvious implication on the face of the permission, so something in form that it indicates that individual acts of development have been separately authorised. But also, we're looking for evidence in the substance of the evaluation, in the officer's report and the environmental statement, that possibility was considered, it was identified, and it was evaluated. And that seems to cut against a little, perhaps, the case law about how we interpret planning permissions, that they are public documents, they bind third parties, they run with the land, and that, generally speaking, we shouldn't need to go on some forensic archaeology into all these documents to find out what a planning permission means. We should just be able to get everything we need from the permission. If the permission is unambiguous, we don't need to go further. But this judgment seems to be suggesting that you do need to at least find evidence that an authority considered and approved the individual components of a scheme coming forward separately. So that's point 2. What are we looking for? Those are the types of things. But what about ITV Studios? I mean, no magic about this case, this particular appeal decision, or why I've picked it. It's a recent appeal decision. It's been noted on social media as having a description of development which included the phrase, each phase being an independent act of development. Each phase being an independent act of development. And that, on its face, sounds a little bit like a planning permission that's granted for multi-phases as severable from the whole. And it was subject to a planning condition that the phasing hereby permitted shall be carried out in accordance with the approved phasing plans 1, 2, and 3, with phase 1 being the first to commence. But as I say, initially promising, but when we dig into what those phases are, my very firm view is that that really isn't anything to do with a severable permission, and probably everything to do with community infrastructure liability. The 3 phases in that case were the demolition of the existing building, the ITV Studios, so point 1, that's phase 1. Phase 2 was the construction of the basement, that's phase 2. And phase 3 was the construction and erection of the building, the tower scheme that was granted permission on top of it, that was phase 3. There was no suggestion in the appeal decision and the consideration of that by the Secretary of State or the inspector that those individual components could come forward individually. It would be completely inconceivable that the Secretary of State granted permission on the basis that a completely new phase 3, i.e. the new building, which all the impacts really arose from, could be slotted in or swapped out with something else. The whole planning balance was contingent on that individual building. You couldn't have the new building without demolishing the old one. The basement had to be constructed first before you had the building. And so really the practicalities of there being severability between those three phases seems very unlikely indeed. And also, when you dug into some of the documents, the design and access statement, for example, explained that the basement functioned as an integral part of the scheme, that its cycle storage, washrooms, refuse recycling, servicing bays were all vitally important to how the building functioned as a community space and as an entertainment space. And it was just inconceivable that you'd have a different form of basement, I don't know, with all residential or all data storage or something completely detached from the building. That isn't in any way what the appeal decision seemed to be predicated on. So it seems to me that the ITV Studios description of development was all to do with ensuring that the individual phases were articulated clearly enough in the decision to ensure that community infrastructure levy liability didn't bite for the whole scheme as soon as it was commenced by the act of demolition. And as we know, the regulations do make provision for phased development, and Regulation 9.1, they provide that where you do have a phased scheme, each phase is a separate element of chargeable development. And so the SIL, such as it might be for each phase, bites when that phase is commenced rather than for the whole scheme when you commence the individual development. Also, the other thing to bear in mind with that case is that the description of development, which finds itself on the decision letter, is the same description of development that was in the original application form, certainly in relation to that tailpiece phrase, each bit being an individual act of development. That application form certainly predates Hillside in the Supreme Court. It also predates Hillside in the Court of Appeal. And whilst it did post-date Hillside in the High Court, it seems quite unlikely that that was drafted with a view to creating individual severable acts of development. So that would be my view on that case, which has done the rounds a bit on social media. So finally, how do you frame a permission? Well, I think the first thing to say about this is, and this may be me being overly pessimistic, but I cannot conceive that it is going to be at all easy to draft a permission in light of Mr. Justice Holgate's judgment and Hillside that is going to be a successful severable permission. I think the safest thing to do if one were seeking to achieve drop-ins would be to take up the Supreme Court suggestion of a brand new planning application which covered the whole site with all the same development that was there, plus the extra bit or the different bit that you wanted to construct. That is clearly the safest route. It's not without its problems. Obviously, you need a new planning application fee. You'd be up against all the new planning policies that existed at the time. There may well be new SIL requirements, because if you'd already built it, it would be retrospective development and that would have SIL implications. So it's not a good solution, but it is certainly, I think, a safer solution than trying to devise a permission which ticked all of Mr. Justice Holgate's boxes. But what could you do? Well, I'll have to offer some options. I think the first thing you'd be looking at is in the application form and its supporting documents, you would need to show that the description of development particularized and described the severable parts of the permission as individual acts of development. It would need to spell them out and describe them and make them very clear that they were separate and what they comprised. You'd need to be careful that the documents you were incorporating, either by the decision, the description of development, or the conditions, also made clear that they were being treated as individual components of development. For example, the design access statement would need to make clear that each different component was intended to operate independently if necessary. The planning statement would need to perform a planning balance evaluated against the development plan policies for each individual component. So would any environmental statement, so would any landscape and visual impact assessment, so would any heritage assessment, so would every other document, I would suggest, would need to show that the component parts could be justified in planning terms on their own individual four corners. Secondly, I think the conditions and any planning obligations would need to avoid requirements for adherence for any site-wide master plan or any other site-wide strategy, which of course was one of the points which fell down in Dennis, the DAS. There was requirements to comply with the DAS. The DAS had a phasing strategy that suggested the whole scheme would be coming forward in a particular order. That, the judge said, was inconsistent with treating each phase as an individual component of development. You'd also need to be very careful that the individual infrastructure triggers were carefully tuned to the impacts of each phase. A, because to try and avoid the Hillside problem, but B, because if you were granting permission for each individual phase and you hadn't properly assessed the infrastructure requirements, well, the decision may well be exposed to legal challenge, because it might be said that you've been relying on another phase which may never come forward because the scheme was designed to be severable. I think it would be useful and sensible to have an informative on any decision notice. Obviously, informatives don't carry any legal weight, but it would further make clear the decision taker's intention. It would be on the face of the decision notice, and it would therefore communicate the intention for severability to third parties and anybody else with an interest in the permission. And finally, any officer's report or minutes, a committee decision, would need to very clearly evaluate the merits of each individual phase. They'd need to make sure they were justified on their own merits, and they'd have to contemplate and expressly approve the situation of each phase coming forward without any other development. Now, that is, of course, all where a decision is granted in accordance with an officer's recommendation. Who on earth knows what a committee would do or supposed to do if it had a recommendation for refusal and then it wanted to grant planning permission for a severable development? It would need to spell out, I would suggest, in its minutes, and the minutes themselves may need to be many pages long to show how each individual component was found to be successfully justified on its own planning terms. So I don't wish to be pessimistic, but I think it would be extremely difficult to do it, and I would tread extremely carefully before trying to draft a permission which achieved individual severability of its component parts. Thank you, and with that I'll hand over to Jenny.
Thanks very much, Ashley. Good afternoon, everyone. I'm going to talk about how to deal with this retrospectively. Ashley's just been talking about what you can do or can't do, looking to the future in how to sort of design a new planning permission. I'm going to think about for a few minutes how you deal with the problem retrospectively, or how you can't, following Dennis. So let me just make sure I can click. Here we go. Here we go. Yeah. So just in light of Dennis then, what is the scope? Is there any scope left for altering the bundle of rights granted by the permission under section 96A? I mean, I think the short and easy answer to that is probably no, because changing the architecture of the permission in terms of changing its parameters and structure legally is almost certainly likely to be material, and that's almost certainly likely to be a question of law rather than a matter of planning judgment. Because, for example, if you have a permission that on the one hand is severable, then if you drop in an application, you can continue to build out the remainder of the outline with no problem. If you have a permission that's non-severable and put in any drop in, you can't continue to build out the remainder of the outline in accordance with its terms, and you're prevented from exercising those rights. There's obviously a material change between those two, and that's what Dennis found. So section 96A, which is about non-material change, can't be used, I think, can't safely be used in that way. Could it be done by section 73 by amending the conditions? Perhaps in theory, because under section 73, it doesn't have to be non-material. It does have to relate to conditions, and I'll come back to that. So potentially, in theory, you could think of a way in which the conditions could be structured to alter the architecture of the permission to make it potentially severable, albeit all the reservations that Ash has just set out. But really, how would that work in planning terms to retrospectively change something that has been comprehensively granted with all the bits relying on the other bits for the planning balance? And then how can a local planning authority safely consider that, well, we can just drop this bit out and enable it to come form in an entirely different form, whilst still allowing the developer to build out all the rest that we've already granted permission for. And as Anjoli hinted, the difficulty, I think, with this is that the rationale behind it all, if the planning authority safely tried to do that, there would be this disconnect where there would be no guarantee or no assurance for the authority in making that decision that the effects of the drop-in on the outline would be considered when the drop-in was determined. And that's the effect of Pilkington and Fisk, which make clear there's no duty on the local planning authority to consider the implications of the permission it's granting on other extant planning permissions. And there's a number of reasons for that, including that, for example, the extant planning permission that's way back in the planning history might never be built. So why should that be a constraint on an application that they are considering on the table that day? But the effect of it is that if you're reconsidering the architecture of the permission, how can the LPA be assured that then allowing drop-ins later will consider that there will be a suitable control on the effect of that drop-in in terms of its planning impacts on the neighbouring development in the remainder of the outline? And that's the problem. There's no assurance, there's no legal mechanism to ensure that happens, which makes it very difficult, I think, for a local planning authority to design in principle in flexibility retrospectively in advance of any potential drop-in coming in. So I say it's more straightforward if you're accommodating a known scheme rather than trying to shoot for the moon and accommodate all potential future schemes by altering the legal architecture. So in terms of a known scheme, it's a fairly well-trodden route now following Hillside. There's been some ingenious ways of looking at this, but just I've set out briefly there a sort of checklist as to what to consider when looking at how to accommodate the drop-in and ensure that the outline still remains valid and able to be implemented. First of all, of course, look at the degree of flexibility in the outline as it stands. Check the interpretation principles. Does the outline incorporate documents as it did in Hillside? Sorry, not in Hillside, in Dennis. Does it incorporate a whole load of matters into the description of the development, meaning it's less flexible? Or is it more of a bare outline and more flexible? You may be able to get your drop-in in without too much trouble if it's the latter. Also consider the stage of the outline. Have reserved matters been approved? They may have been approved, but there may be flexibility to make new reserved matters applications if there's still time, if you're still within the time period. And again, effectively converting the outline back to a bare outline, even though reserved matters have been approved and you can swap in new ones. Then you need to consider, well, what would be the physical compatibility or incompatibility with this drop-in and what was there before? What is in that place in the outline? What will be the planning impacts of that change? Are the inconsistencies material or substantial or neither? And those words are key words, which I'll come back to because they are relevant to the tools you have in amending the outline to make it consistent. Also consider, are there inconsistencies with the description, either the operative part of the permission or with the conditions or with the approved reserve matters details? All those issues will affect whether and how you can amend the outline to make it consistent and to avoid the Pilkington problem. And all that will feed into what would be the legal effect on the continued implementation of the outline. And once you've got all that information, you can consider how the outline, or if it's by that stage a larger full permission, because, for example, all the reserved matters have been resolved and approved and can't be changed, or if it is from the outset a full permission, consider how that can be amended to resolve inconsistencies and to avoid the Pilkington problem. So what tools do you have in your box? Well, at the moment, for the description of the development, you only have section 96A. And of course, that is only for non-material amendments. Now, the Dennis case may put a bit of a fright behind people trying to use that now because the court clearly found that it didn't work in that case and found as a matter of law that the change was material. Indeed, it was accepted to be material if it was from non-severable to severable. But most cases under Section 96A are not of that nature. They are usually a square matter of planning judgment rather than a comparison with one set of legal rights and another set of legal rights. And the change in the drop-in, from the drop-in to what should be there from the outline, there may well be a wide scope to argue that that is not material in the context of the scheme as a whole, in the context of the wider scheme as a whole, even if there's a material change of use, even if there's a different height, different density, different layout. There may well be scope to show that in the context of the whole thing, this whole big master plan, it's not material. And actually, if you can be confident of that, in a sense, you don't need Section 96A at all, because that would only confirm that position. And as Anjoli said at the outset, Hillside was clear that the Pilkington principle should not be pressed too far. So if you're confident that your drop-in is not materially different from the terms of the outline in planning terms, in planning judgment terms, then you don't need Section 96A. You can just go ahead confident in the position that the outline or the continued implementation of the outline won't be affected. But of course, there are many good reasons why you'd use Section 96A to confirm the position and get that reassurance and avoid the legal risk. Other option, Section 73B, that's not yet in force. That's under Section 110 of the Levelling Up and Regeneration Act. That enables an amendment if the LPA is satisfied that its effect will not be substantially different from that of the existing permission. Query whether substantially different is much different from material. It's clearly intended to be because of, if you look at the parliamentary debates, but also the heading of sections 110 is about material variations to planning permissions. So that gives a little bit more leeway in terms of the planning judgment, I think, to decide that something is capable of being amended and that the description is capable of being amended, even if it is a material change. But as I say, that's not yet in force, and it's in force on a date to be appointed, so we don't know when. The other tool at your disposal is Section 73. Obviously, that's not strictly an amendment tool. That's a grant of new permission with different conditions. I'll just briefly spend a couple of moments thinking about what that how that can be used. It's obviously very useful in amending supporting documents and plans linked to conditions. But beware, check whether the supporting documents and or the plans are actually incorporated into the description of the development as they were in Dennis. And there's a bit of a useful discussion in the recent High Court decision in Armstrong, where it didn't become an issue, but it could have done. So if your plans or documents are incorporated in the description, query whether really you can amend those because they're part of the operative part of the permission, even if they're also referenced in a condition. Also, if you're slotting out a part of the development for a future approval of a drop-in, so you're effectively nullifying an approval of reserved matters in relation to that by amending a condition, beware that that may conflict with the purpose of Section 73(5), which prohibits using Section 73 to amend the timetable for approval of reserved matters. As most people now know, following Finney, Section 73 cannot be used to introduce a change that is inherently inconsistent with the description of development. It can only be used to amend conditions. And if that condition change is inconsistent with the description, even to a minor degree, even to a very minor degree, and that was confirmed in the High Court decision in Fisk, different case from the Court of Appeal decision in Fisk that Anjoli mentioned, even if to a minor degree, then you can't use 73 to change it. But if you can do it by condition and it doesn't affect the description, you may well be able to use Section 73 to introduce really quite fundamental changes. There's some dispute between the cases as to whether that's the case, but Armstrong, fairly recent High Court case from last year, James Strawn sitting as a deputy High Court judge, he set out some quite detailed and persuasive arguments in paragraph 73 to 89 as to why Section 73 can be used to make really fundamental changes, so long as the description's not affected. Contrary position in Fisk, but I think there's an argument that Armstrong is better set out and more comprehensively argued and should prevail in that respect. But once you've done all that, if you've made the outline permission so consistent with the drop-in, so you've effectively amended the description and amended the conditions to accommodate the drop-in, arguably, you probably don't even need a drop-in permission. You can just build the drop-in site under the outline. So it's it's debatable really how that is a wheeze, or whether it's effectively getting a new permission that incorporates the drop-in from the outset. Anyway, those are my thoughts on what you can do, and I think we should move on to a wider debate on some of the questions that have come in. So I'll hand back to Sasha.
Jenny, thank you. Thank you. I'll just wait for us all to appear on the screen. I'll let you into a little secret. In 1991, one of the temptations of going into planning was apparently it wasn't very legal. But I think we've proven across the past hour that it is pretty legal. But I think those were 4 absolutely superb presentations. So on behalf of our audience, can I thank the 4 of you for dealing with a tricky area in such a brilliant way. So thank you. I've got a few questions. We've got about 8 minutes left of the webinar, so just a few questions. And Jenny, as you're warmed up, can I start with you? And could you give some practical advice, particularly to those that work for local authorities, in the light of Fisk? What approach would you recommend officers took for when they've got a new application before them, how they deal with that knotty issue of the consequences of the existing permission? What would you say? What tramlines or guidance would you give?
So you mean when you're looking at a drop-in application, whether you take into account the effect of that drop-in on a pre-existing outline?
Exactly.
I mean, well, yes. I mean, first of all, there's no legal duty to take it into account, as Anjoli said. Fisk and Pilkington make that clear, and there's good reasons for there not being a legal duty. So it's not a mandatory. It's not just by virtue of its inconsistency doesn't make it a mandatory material consideration. That said, of course, it may bring in considerations. So there may be, I think this is mentioned in one of the questions, it may be that if your drop-in prevents the wider outline from being implemented, then there may be knock-on issues on housing, land supply, or on meeting other needs if you're going to sort of stymie that wider development. So for that reason, it would be worth thinking about it, and it would be worth taking into consideration. Also, I'd say it's sensible to take it into account, because if you're going to grant the drop-in, and you have properly considered the planning implications of doing that on the outline, and you've properly satisfied yourself that it doesn't prejudice it, not just in legal terms, but it doesn't prejudice the scheme as a whole and its planning balance or landscape impacts or whatever, then the whole thing is likely to be much more robust. And unless you've got a sneaky desire to render that outline permission incapable of being implemented, then the sensible and pragmatic approach would be to take it into account and square it as part of the decision making, because that would then also make it much harder to enforce against, or for someone to say that you are not acting expediently in enforcing against the building out of the outline, because you've properly considered the implications, and it would make it kind of sort of not rational to then enforce against it later. So if, as a local planning authority, you have an interest in, and presumably you do because you've granted that outline permission and you're seeing the regeneration scheme come forward, the best way to make it robust with the drop-in is to make sure you consider the implications of the one on the other when you're granting the drop-in. That would be my position or advice.
Thank you, Jenny. Right, Alex, can I ask you a question that one of our audience has asked? Was in Dennis, was the section 96A application, was it seeking to actually alter the description of the development or not? And if it was, how do you contrast that with what you can do under a section 73A application?
Yes, that's right. a curious feature of Section 96A that it can amend the description of development, but Section 73 can't. And I think that works in theory, because unlike Section 73, the change needs to be non-material. But if that's so, query what's the point of Section 96A if it can only make these non-material amendments? I can see, for example, an amendment that's more planning judgmenty, so adding in an extra flaw when there's already a lot of flaws might be a benefit that you can't achieve via Section 73. But other than that, it is the question from the audience is right. It is curious that this mechanism was used. Jenny, I know you have a few thoughts on this as well.
Yeah, I mean, just a straight answer. I mean, yes, in Dennis, I think it clearly was a change to the description of the development. It was just inserted the word severable into the description of the development. So it was saying, well, we're going to declare it so it shall be so. And of course, that was, we all know, material because it changed the rights and the structure and what could be done under the permission. But that's the only way you can do it, by the description. As I said, you can't do that under Section 73. You'd have to think of some ingenious way, I think, if you're going to do it by Section 73, which then can be material. You'd have to think of some ingenious way of doing that by altering the conditions and the documents approved under the conditions, which might be possible, but I explained why it might be difficult to do that, to envisage what effects that would have in planning terms on, in all future scenarios.
Thank you, Jenny. Thank you. Now, Ashley, can I ask you, let's cut to the chase in the light of your presentation. Do you think, in the light of Dennis, it is realistic that can you envisage the courts actually considering a planning permission does have elements which are severable?
Probably not. I think it's very unlikely they would. I think the terms in which the Supreme Court cast the presumption, the terms in which Holgate has identified where it would apply, the practicalities of a planning authority considering even just severing a large permission in two would be complicated. I mean, they would have to look at every element of that scheme twice. And, the local authorities and planning inspectors sometimes overlook material considerations when they're considering it once. So I think for all those reasons, the litigation risk of contemplating severability without considering something coming forward in a particular way all means, I think it'd be very unlikely an authority would want to do that, would be motivated to do it. And even if you did persuade them to do it, I think it would be difficult to identify a case where it was done successfully.
I mean, I suppose you could, sorry to butt in.
Go on, Jenny.
I mean, I suppose, the way Holgate defines severable permissions is effectively a number of different permissions, and which begs the question whether having 5 different permissions or 2 different permissions on the same piece of paper is any different from having 5 different permissions on different decision notices, which also suggests that if you're going to try and take advantage of severability, effectively maybe that's what you need to do, is just to have different applications, and actually different grants of permission, which then clearly are severable. They're clearly different permissions, and you don't have the Pilkington problem. But then obviously to make that point, to make that practical or useful, you then have to have some other mechanism of joining them all together and allowing the benefits of one to offset the others, to make it a comprehensive thing and then perhaps using Grampian conditions in Section 106 agreements between the various permissions to do that. So that might be another way of looking at it. I mean, I'm sure practically it's pretty cumbersome, but then at least you'd be sure you have different permissions that are severed.
Well, you do get that obviously with allocations, don't you? You get allocations, multiple house builders. If it's a housing scheme coming forward, it's envisaged it will come forward in phases. Quite often they come forward as separate applications, and then the sort of knitting together, the threading together of all of those considerations is done through the policy. And obviously that doesn't work for all development, because lots of development comes forward outside of development allocations. But if you do have an allocation and it says, well, this is expected to achieve this list of things, then at least you can take that into account, I suppose, when you're granting a sort of a little part of a wider envisaged project. But I still think it's going to be challenging, isn't it, to do that, because as you say, the only answer of really achieving it would be to have wholly separate individual grants of permission in separate decision notices.
But as you say, but as you say, under that sort of situation, a large comprehensive policy for a regeneration scheme or for a particular area, that may well envisage a number of different permissions anyway, which could be knitted together by the policy. And then in light of the current climate, the judicial climate, you would think, well, there's not much benefit in putting in in seeking a big one application. Why don't you embrace that the policy is the glue, and you may also need conditions between them as well. But that's the glue, and that then enables later flexibility, at least between the different permissions, rather changing the permissions later. So yeah,
with some schemes doing that retrospectively, so carving out an existing permission, so amending the red line, for example, to carve out the area of land that you then want to effectively amend, and then having a new application sitting alongside that, which essentially exactly slots in, so there's no physical incompatibility between the two. And again, that's the using just wholly separate permissions to achieve that kind of result if you haven't designed it in advance, because obviously there'll be lots of permissions which haven't been designed that way, which are already been granted and being built out.
Yeah, but would there be a potential problem with that slotting out decision? Because if you have to amend the description of the development to remove a large part of the site, arguably is that material? It might be difficult to say that's not material.
No, you'd have to amend it with a section 73, I'd have thought.
Yes. So as long as it doesn't affect the description of the development, if we want description of development. So I suppose if the description of development includes the development, the type of use, like the retail or whatever that was going to be on that site, it's difficult. You can't just then take it out.
No, you'd have to, I suppose, in that scenario, use a combination of 73 and 96A to achieve the carve out, and then
and rely on the planning judgment that removing the whole retail use is not material, for example. It just
Well, listen, I think this is indicative of the fact that we could go on for an incredibly long time, but I am conscious that we've come to the end of the time allotted for the webinar. And I want to thank, on behalf of everyone, the 4 superb presentations. And I also want to thank everyone who's joined us tonight. And we really appreciate your involvement and coming to hear what we've all had to say on this very, very topical and seminal issue affecting our practices. So thank you very much, and we hope to see you all soon on a subsequent webinar. So thank you.